Good morning, Chief Justice Roberts. It's an honor to have you here.
Thank you. What's up?
Now, we're just going to get into some questions about this Supreme Court case that has been on the minds of a couple people.
Yeah, O'Connor Ratcliffe v. Gardner.
You know it.
Yeah.
Alright, let's start this off. Which of your previous employment experiences have helped you achieve the title of Supreme Court Justice?
So after graduating from Harvard Law School, one of my first jobs was being a clerk for then Associate Justice and future Chief Justice William Rehnquist. I also worked at the White House Counsel from 1981 to 1986 under the administration of Ronald Reagan. And I was also the Principal Deputy Solicitor General under President George H.W. Bush from 1989 to 1992. After that, I spent about 10 years in a private corporate law firm in D.C. until in 2001. President George W. Bush nominated me to the U.S. Court of Appeals for the Circuit of the District of Columbia. I was confirmed in 2003. And then in 2005, as a result of Chief Justice Rehnquist passing away, President Bush actually nominated me to become the Chief Justice of the Supreme Court, and I've been serving in that role since that day.
So you've got quite a lot of experience in the judicial system.
Yeah, thanks so much.
Yeah, of course. With what party do you align yourself politically, and how do you think these affiliations affect your judicial decisions?
So, I wouldn't want to say that I'm aligned to a political party, because the Supreme Court is supposed to be sort of apolitical, unaligned body. As a Chief Justice, I think it's especially important to emphasize that. But just to make things simple, although President George W. Bush did nominate me and he was a Republican, so I guess I would say that I'm aligned to the Republican Party, even though I wouldn't say I am in the Republican Party.
That's a very solid answer. That's what we want to hear as Americans.
Thank you. Yeah.
Do you have any past cases, or do you know of any major cases that are similar to this one?
So, two cases that come to mind, they're actually related as well. Waters v. Churchill, 1994, and Heffernan v. City of Paterson in 2016. Both cases sort of established a precedent that when public employees speak as private citizens on a matter of public concern, then their speech is protected by the First Amendment. But if the speech is part of their official duties, it may not be protected. And this is in the context of if the speech is happening in a public forum. And in O'Connor Ratcliffe, the question is the social media platform a public forum? In the case of Waters, there was a public hospital, and a nurse was fired for speaking out against her employer. In the case of Heffernan v. City of Paterson, a police officer was fired for picking up a campaign sign for a local political candidate. And really the question is, since the parents in O'Connor Ratcliffe are discussing a matter of public concern, that may be entitled to First Amendment protection. So
Yes.
It's really just those precedents that matter.
So the main question is the internet a public forum?
So that's what we would that's what we would be discussing during the oral argument.
This is great. How do you think this is going to affect future use of the internet?
Well, I don't want to speculate, but speculating, if the ruling is in favor of the trustees, so O'Connor Ratcliffe, then that would mean that the public officials on a larger scale now, so not just school board members, but it could extend to politicians, maybe members of Congress, maybe members of a presidential administration. They may be able to use the block feature or something similar on social media platforms. There also was a similar case. The name of the case doesn't come to mind, but it was basically President Trump, the previous president. He on his Twitter account @RealDonaldTrump, he blocked a few people, and the question was, as a public official, as the president of the United States, is you allowed to do that? And I'm not really sure how that case went to the top of my head, but basically, if this actually might be a landmark decision. If O'Connor Ratcliffe wins, then that means public officials may be able to use the block feature or anything similar on social media platforms against citizens who also happen to be social media users. But if the ruling is in favor of Garnier, in favor of the parents, petitioners, then that would mean that public officials may not be legally able to use the block feature. Although there may also open discussion on whether or not, the block feature can be used to deter harassment and what qualifies as the rights of a public official versus a private citizen.
Okay. The case that you were talking about is Knight Institute versus Trump.
Yeah.
And they did rule against Trump, saying that, of course, that's blocking and violating the First Amendment.
Yeah, sorry. It didn't come to my mind because it was a Court of Appeals case, not a...
Yeah, of course. No, that's completely understandable. How political do you feel like this case is? Do you think political alignments will affect the other judges' decisions?
Sure. I don't think so. I think this is a pretty objective case. It's really just, can a member of a public body use a block feature on social media? Is that in their official duty? Is that allowed? Is that restricting the freedom of, freedom of speech, freedom of petition? I don't think it's very... I don't think I would say it's very political. No.
Thank you for your time, Chief Justice Roberts. It has been great having you. And we will see you, the viewer, next time.